recording. Let's see. Okay. So this is our basics of land use planning and regulation training. This is something we do on an annual basis, Wyndham Regional Commission. I think, as you all know, one of the main roles that WRC plays is providing technical assistance in terms of planning and zoning to our member towns. And so this is one component of that technical assistance that we provide to towns. We are available to meet with towns as well on a kind of as needed basis um, to help towns address more specific issues that might come up um, in for a planning commission, DRB, or a zoning board. But this presentation, it's really meant to be a general overview of the basics of land use planning and regulation. And just, I always say this at the beginning of kind of any presentation with towns is we're not able to provide legal advice. So if you have any questions that are more of a legal nature, always consult with your town attorney. But today I'll go over four main areas. We're going to talk about planning for your community. So this is focused on the town planning effort. The second section is implementing the plan. So implementation steps after you have adopted a town plan. We're going to talk about roles and responsibilities. So in terms of boards and commissions and municipal staff. And then talk about meetings, hearings, and due process. So some of the more the technical components of running good meetings and making sure you're in compliance with open meeting laws and things like that. And like I said, after each of these sections, I will pause just in case there are any questions. Um, if you have any questions while I'm going through slides, feel free to chat question or put in questions in the chat box as well. So the first section we'll be talking about is planning for your community. And just to provide some context in terms of how planning is done here in Vermont. So Vermont is known as what is called a Dillon's Rule state. And this means that municipalities can only do things that are enabled by the legislature in state statute. So there are other states in the country where municipalities have more leeway in terms of actions they can take, but in Vermont, we're guided by what is included in statute. And statute also includes things that towns are required to do in terms of what's required to be within their zoning bylaws. And most of the provisions in statute related to land use planning are found in the Municipal and Regional Planning and Development Act. So that's in chapter or 24 VSA, chapter 117, 4301 through 4498. So that's the bulk of the statutory requirements for towns are in that section of statute.
I hate to interrupt. Are you trying to proceed with the slides, or are you still on the first slide on your end?
Oh,
Because
I see.
I don't think we can see.
Okay.
There we
Can
go.
you see this
Cool.
now? Okay.
Yep.
Thank you.
Hmm.
Thanks for letting me know. So so yeah, this is kind of where I was going over just Vermont being a Dillon's Rule state and towns needing to follow um, what is required and allowed of them in statute. Um, and here on the slide, this is just the section of statute I was referring to, the Municipal and Regional Planning and Development Act. So I would recommend the state has a very easy to navigate website for its statutes. All the statutes are online. You can click on each individual section of statute. You can download a PDF of the entire Municipal and Regional Planning and Development Act to have just in your records and do searches within that PDF. Um, so I know it can feel daunting having to navigate statute requirements, but I think Vermont does a good job at making them pretty accessible. It's a good idea to review statutes on a regular basis. As you know, each year it's pretty common for the legislature to make changes to statute requirements. And the Department of Housing and Community Development puts together a memo on an annual basis that just summarizes any planning related statute changes. And that's available on their website. Um, and so that's an easy way to see what has been changed by the legislature, versus having to keep track of all the separate bills going through the legislative process. Um, so in terms of kind of the main elements of land use planning and regulation, so again, statute authorizes what municipalities can do in terms of planning and how they implement their plans through land use regulations. Um, and statute provides for towns that they can adopt a municipal plan. There are specific requirements, which we'll get into. Um, and then statute also lays out the different implementation tools that can be used. So that includes regulatory. Those are the most common ones we think of, zoning, subdivision bylaws, but there's also non-regulatory implementation tools too, which we will discuss. So first, I'll talk about just an overview of what the municipal plan is, and then we'll talk about some of the benefits of having a town plan and the process for developing a plan. So the town plan, it's meant to be a visionary document. So it's looking backwards to see, what the existing conditions are in the town, what have some of the trends been, issues and concerns. But the focus is really forward-looking and trying to define a path for the community going forward. What direction does the community want to go in? It provides guidance for achieving that broad vision and goals for the town, and sets forward specific action steps that the town's going to take to achieve those goals. So again, this can be through regulatory requirements, through zoning, subdivision, ordinances that a select board may adopt. It can also be non-regulatory, so those might be public investments in important infrastructure or recreational resources. But it's important to remember that the town plan itself is not a regulatory document. It really is just providing that foundation for the town to implement regulatory steps after the plan is adopted. It also provides policies for orderly growth and development. And so the town plan is referred to and considered in the Act 250 and Section 248 state permitting proceedings. The town plan does have more weight in Act 250 than it does in Section 248. But this is another reason why it's important to have very clear policy language in your town plan so that it's easy in those state proceedings to point to relevant policies that support or do not support a proposed project. Oop. So some of the reasons to have a municipal plan, towns are not required to have a town plan. We certainly encourage towns to to develop a plan, but it's not a requirement by statute, unless you are required to have a plan to have zoning bylaws, but if you don't have zoning, then it's not a requirement. But the town plan, it empowers a community to respond to changes in a way that reflect their needs and priorities and values. So the state requirements for what needs to be in your town plan are pretty broad um, in terms of the statewide planning goals and the required plan elements. So there's a lot of opportunity for towns to still develop unique plans that work best for their communities while meeting those statewide requirements. It, through the land use plan component of the town plan, it allows towns to designate areas for conservation purposes and for different development needs within the community. So this is the first step to develop zoning bylaws, or if you need to amend your zoning bylaws, doing this through the town planning process. It helps establish a transparent, consistent, and predictable public policy. So once the town plan is adopted, that's a guiding document for the Planning Commission and for the Select Board. In terms of implementing the plan, it spells out what the town's goals and priorities are. So that helps residents and community members see what direction the town is going to go in. And then finally, town plans help promote wise investments and they help manage future costs. So it's an opportunity for towns to think about what their needs are in the future and to start planning for those and figuring out how they're going to support funding those different facility and infrastructure needs so that they can manage the town's finances. So some additional benefits, as I mentioned, a town plan is required in order to have zoning, subdivision, and flood hazard and fluvial erosion hazard area bylaws. So you need to have a town plan in place to adopt those bylaws. The town plan is considered in the Act 250 permitting process, so it gives the town additional standing in Act 250 proceedings. Also, recommendations from the town plan are given due consideration in Section 248. So that's for energy generation and transmission projects. And then it's also having a town plan is a requirement for certain grants. So for if a town's interested in a municipal planning grant, having a town plan in place is required. There are also other state grants where a town plan is a requirement to be eligible for that grant. So next I'll talk a little bit about the general steps in the planning process. So step one is always the community assessment. So this is at the beginning of the planning process. It's really trying to get a sense of what the conditions are in the community today. So this is under this step, a town would be collecting relevant data on population, housing, economic conditions. This is also an opportunity to do public outreach. That could be through a community survey, holding different types of public meetings or events. And then also during this step, I recommend towns look at past planning efforts and studies. So town plans need to be updated every 8 years, and often there's a lot of work that's done in a community during that 8-year period. So this is a chance to look at those other relevant plans and studies and make sure that in updating the town plan, you're incorporating them, especially a local hazard mitigation plan, um, a more significant study looking at, for example, pedestrian and bicycle improvements within the village area. Those types of efforts, you want to make sure that um, those are incorporated into your town plan. Step two is analyzing that community assessment. So um, looking at all the existing conditions and the feedback received through the public outreach process to begin establishing goals and objectives um, based on what a community has heard. Um, the town plan may include many goals and objectives that continue to make sense for your community. And so often this is kind of reviewing and updating your goals and objectives based on how things have changed in the last 8 years, but not necessarily starting from scratch. And then building on step two is kind of drilling down and identifying more specific policies, policies and action steps to achieve those goals. Step four is creating a program to implement the plan. So what I recommend is once you have those action steps, simply putting them in an Excel spreadsheet, um, and then you can start identifying who's going to be responsible for each of these tasks. How long do we think it's going to take to complete it? Is this a priority we want to get done right away, or is this more of it would be nice to do this if we have the resources and time. Um, and then that implementation program can be referred back to once the plan is adopted on a regular basis, so the town can track its progress um, in implementing the plan. But I'm getting ahead of myself. So step five is going through the process of holding public hearings and adopting the plan. And then step six, you move into implementation. And again, it's important to, even on an annual basis, for the select board and planning commission to have a meeting to go over the that implementation program and talk about priorities for implementing the plan, just so that the plan stays relevant and continues to be used by the community once it's adopted. And then step seven is evaluating the plan and planning program. So this, I recommend, at least 2 years before the plan expires to start the process of looking through your plan. This is a chance to update background information, start thinking about what the big changes in the community have been, and this will just make it easier to move into that first step of the community assessment um, for updating your plan. So at least, yeah, 2 to 3 years before that 8-year expiration date to start thinking about the process of needing to update the plan. So state statute includes requirements for what needs to be included in your plan, and then also it has specific goals for the planning process. Um, so these are the goals for the process a town goes through for adopting its plan, and also the implementation phase of the plan. These are the goals from statute. Towns need to establish a coordinated, comprehensive planning process and policy framework to guide decisions. They need to encourage citizen participation at all planning levels, consider the use of resources and consequences of growth and development for the region and state, as well as the community in which it takes place. and encourage and assist municipalities to work creatively together to develop and implement their plans. And one thing I would just note is, you know, town plans are more likely to be implemented in a community if there's a strong planning and a strong and inclusive planning process that is followed to get to the adopted town plan. If there's a lot of community involvement and excitement about the town plan and the planning process, then um, towns are more likely to have buy-in to implement specific recommendations in the plan. So the process itself is very important to having a successful plan. And thinking about the planning process and public engagement, there are different levels of public engagement. And this is a common way they're broken down. And this is kind of seen as a spectrum of from less involvement to more involvement. Um, so there's inform, consult, involve, and collaborate. The first one, inform, this is really just making residents aware of a planning process. So this could be having something on your website that the town plan is being updated, uh, inclusion in a newsletter, something along those lines. So it's really just a informational, this planning process is happening. Um, Consulting provides an opportunity for input um, on existing ideas. So this could be through a community survey where residents are asked to respond to specific questions. It could be a public meeting. Involve, this provides opportunities for dialogue and interaction. So obtaining advice from the public and generating new ideas. So this is more of a collaborative process. And this would be more through workshops or focus groups that are getting more into details on specific components of the town plan. And then collaborate is the greatest level of involvement. And so this is where the public is really involved in the decision-making process, looking at alternatives and identifying a preferred solution. And I think it's important in the planning process to be clear and transparent with the public about how their input will be used in developing the plan, um, and making sure that you pick the right type of engagement for the planning process you're engaged in. So, um, for example, during the town planning process, you might focus more on informing, consulting, and involving kind of those levels of engagement. The collaboration um, that can be used in a town planning process, but that is often more used in a more specific follow-up study or plan. So, for example, if you developed a town plan and one of the goals was to um, do a scoping study to look at pedestrian improvements within an area of town, that might be a better opportunity for collaboration with residents where it is a more specific project and you're looking at alternatives for that project. Um, so I think it's important to just keep in mind these different levels of engagement and picking the right type of engagement for the project you're working on. Um, and remember too that residents are comfortable with engaging in the planning process in different ways. So I think always having a variety of different options for people to participate is helpful. Some people just want to take a survey. Some people want to attend multiple focus groups. So having different options just lets everyone participate. Um, so the next two slides are they're a little more technical, kind of going over the specific requirements from statute for the town plan. Um, and this first slide covers the statewide planning goals. So these are outcome goals. So in statute, town plans are required to demonstrate that they are working towards these goals. And in statute, these 15 goals are spelled out in more detail. There are more specifics in the statute language, but this kind of provides a summary of those goals. I think we're all pretty familiar with these, but just to go through them quickly, we need to be planning for compact villages, strong agricultural and forest industries, strong diverse economy, flood resilient communities, education and vocational training, wise and efficient use of natural resources, safe and affordable childcare, preservation of natural and historic resources, efficient efficient public facilities and services, quality of air, water, and wildlife resources, recreational opportunities, safe and convenient transportation, safe and affordable housing, and energy efficiency and renewable resources. Um, and there's goal number 15, which was added with the passage of Act 181 in 2024. So this is a new statewide planning goal that needs to be addressed in town plans, and that is equitable distribution of environmental benefits and burdens across the community. So um, making sure that the town plan is not in any way concentrating environmental burdens that would disproportionately impact a certain area or population in town. Um, and then the next slide, these are the town plan elements. So these are the previous slide was more planning goals, kind of outcomes. And then these are the more specific sections that need to be included within your plan, the topic areas that are addressed. So that includes your statement of objectives and policies and programs that are guiding future growth. Um, you need a land use element, transportation element, utility and facilities, a statement of policies on preserving natural areas, scenic and historic um, resources, educational facilities plan, a recommended program for implementation of the objective. So that's the implementation program. You need to include a statement of compatibility with adjacent towns and the regional plan, just how your town plan relates to the town plans for surrounding communities and what is included in the Wyndham Regional Plan. You need to have an energy element, and there is the option for an enhanced energy plan under Act 174 to include that within your town plan. A housing element, economic development, and flood resilience. So those are the different chapters that need to be included in the town plan. And I have just two more slides on town plans, and then I'll pause for questions. Just to go over the town plan adoption process. So as I mentioned, your town plan expires every 8 years. It used to be 5 years, almost extended to 8 years several years ago. Just be aware of the amount of time you think you might need to complete an update to your plan so that you can have it updated and adopted before that 8 year deadline. Sometimes there's a lot of change in a community in 8 years, and a more extensive update is needed. Sometimes not much has happened, and it's a relatively straightforward update. Um, but at a minimum, towns are required to update the background data, at least hold one public meeting, and review and update the implementation program. So that's a bare minimum of what needs to be done um, to update your plan every 8 years. Um, and then just to note too, the adoption process takes several months, so plan ahead. So you want to make sure that the draft town plan is done well in advance of that expiration date. So the Planning Commission is required to hold a public hearing on the plan and provide 30 days notice to adjacent communities. And then after the Planning Commission uh, provides the plan to um, the select board needs to wait at least 30 days before holding their public hearing on the plan. And then at that point, the select board can make a decision on adoption of the plan, and it goes into effect once adopted. But as you can see with the public hearing requirements, it's at least 2 months from when the plan is done until it could be considered for adoption. So just to keep that in mind when you're creating a schedule for updating the town plan. And finally, just to go over the Regional Planning Commission approval of town plans and confirmation of the planning process. So towns are not required to get approval from Wyndham Regional Commission for their plans. Having our approval of a town plan allows you to be eligible for municipal planning grant and other state grants, and is also required for eligibility for the state designation program. But it's not a requirement. Once the select board adopts the town plan is in effect. It's not as if you need to wait for Wyndham Regional Commission approval for the town plan to be fully effective. Also, I would like to note we're happy to do a kind of informal review of a draft town plan before the Planning Commission holds a public hearing on it to make sure you have the required plan elements. And if you have any questions about changes in statute, um, we're here to consult with the towns. So the goal is to try to address those issues before you go through the adoption process. Um, but if a town does ask for regional planning commission approval, we are required to approve a plan if it's consistent with those state planning goals, if it's compatible with the regional plan and approved plans of other towns in the region, and if it contains all the required plan elements. So that's what we're basing our review on, and these are all laid out in statute. And then for confirming the municipal planning process, we're required to confirm that if the town is engaged in a planning process. So if they have an implementation program that will meet those state planning goals, if it has a process for implementing its plan and it's providing local funding for municipal and regional planning purposes. So I'll pause there, see if there are any questions. Let's see.
Yeah, Matt, we have a few questions in the chat.
Okay.
Um, yeah, so Sue Coakley, hi Sue. She's asking two questions. So one, to guide energy facility siting in a town, how does a town identify preferred sites for siting, e.g. for solar fields, utility grade energy storage facilities? What should be included in the town plan? What role do zoning regs play? Does a town have to have a preferred energy plan approved by the state? And then second question from Sue, what are some best practice examples of how Vermont towns track town plan implementation. Um, yeah, and we have one other in the chat. It looks like I don't know if you want to tackle one of those two
Yeah.
first, or
Let's see.
um,
I'm seeing the question from Patty.
yep,
Yeah, okay. Yeah, I think so I'll respond to maybe and Anand, I don't want to put you on the spot, but for Sue's first question, I don't know if you I'll respond to the second question. I don't know if you'd feel comfortable responding to that first question.
sure.
Okay. So just for the second question, best practices for tracking town plan implementation. Um, that's a great question. I can't think of something off the top of my head in our region. Again, I just my recommendation is putting those action steps in an Excel spreadsheet and kind of using that as kind of like a working document. And I think having a goal of the select board and planning commission meeting once a year, and if that's, every January, they have a regular meeting to go over that implementation program and to, priorities change during an 8-year period that a plan is in place. So maybe some of those priorities shift around. But I think using that Excel spreadsheet kind of as a working document to track progress is a good strategy. And I think when it's in an Excel spreadsheet, you can add notes to that spreadsheet um, about how the town is doing in terms of making progress on the plan. I do think it's important to just keep in mind too, I think, recognizing um, we all have limited capacity, and um, I think it's important to include um, include some action steps in your town plan that might be a stretch, but um, still to try to be aspirational. So I think it's okay to, if, if towns are not able to implement everything in their town plan in the 8-year period, that's okay. There's no one that's monitoring, other than the town itself, there's no one that's monitoring your implementation plan to verify all those projects have been done. Um, so I think, recognizing that things change in terms of capacity within a community over a period of time, but that's just, my recommendation for trying to track that. Um, yeah, Anand, I don't know if you're able to respond to Sue's first question.
Yeah, sure. So you can go about including a list of preferred sites for siting generation or transmission infrastructure. Um, Basically, in one of two ways, you can go about it. You're allowed to do it as part of like a normal energy element in a town plan. Um, or you can go for an Act 174 compliant enhanced energy element. The benefit of the Act 174 enhanced energy element is that it gives your list of preferred sites um, regulatory authority. Essentially, it gives that part of the plan teeth, so to speak. And so if you decide to go for an enhanced energy element, there is a list of statewide identified preferred sites that have to be included as part of what the town is considering as a preferred site. So that includes areas like brownfields, gravel pits. There's a list. I believe it's on the Public Service Department has like an Act 174 landing page, and there's a list of kind of generic preferred sites, and then from there you're allowed to specifically identify places where you'd like to see energy generation facilities. Um, the best way to do that is through mapping those areas, and WRC is happy and willing to provide mapping support in that area. What we also often do is we receive data layers from the state that show areas with strong concentrations of, for example, like solar radiation that can then overlay um, onto your preferred siting map, for example, and allow you to kind of even further define and further hone in where you want those areas to be. Um, the catch is that if you want that part of the plan to have um, a regulatory slant, you have to also go for the other um, aspects of an enhanced energy plan, which includes more rigorous data analysis, the inclusion of energy targets, more specific policies and implementation actions. That's kind of a whole separate ballpark, which I'm happy to answer questions about. Um, but through that process, that's basically how say to the state, you prove to the puck, hey, we're thinking extremely critically about our energy landscape as a town, and we've adopted this enhanced element that supports our planning for where we want to see generation in the future. Um, Hopefully that answers your question, Sue, but I have to follow up too.
Yeah.
Thank-
I'll just say thank you, and and I'll just say that the other element, and we can follow up later, is to understand how it relates to zoning. Because
Mhm.
zoning is land use, whole community. We're in the middle of updating our zoning regs. And it is curious to me that nothing about energy facility siting is included there. And so it's just odd. And we have to do this enhanced energy plan, which seems like a very rigorous process. And I'm just wondering, we can follow up afterwards, but it does seem kind of a anomaly that the energy facilities are not included in any aspect of zoning.
Yeah,
Yeah.
it's the framework is interesting, and I would say that in a lot of ways, the enhanced energy chapter can um, take the place of that part of zoning, um, which is very standout. There's, Matt, correct me if I'm wrong, but there's
Mhm.
not really another aspect of municipal plans that kind of have that role. So,
Right.
um, yeah,
That's correct. Yeah, we can definitely follow up with you, Sue, about it. I mean, one thing too is with renewable energy facilities, those are approved by the Public Utility
Right.
Commission, and in most cases, depending on the size of the project, um, um, it's kind of like local zoning is preempted by Public Utility Commission, making a determination that a project is in the public interest, and so local zoning and the town plan may be considered in that approval process, but especially for these utility scale renewable energy facilities, it's kind of a state level approval with consideration of local regulations. But definitely we can follow up with you on that. It's a pretty long probably follow up conversation. So yeah, we'll
That's
follow up.
great.
Yeah.
Thank you. We'll do
Yeah.
that. We've had two of these proposed in the last year, so
Yeah.
we're
Yep.
trying to make sure that we have our ducks in a row to make sure we participate properly. So
Yeah.
thank you very much for this. I'll
Yep.
follow up.
And just to respond to Patty's question about what a state designation means, so that's referring to the state designation program in terms of designated village centers, and designated downtowns, and neighborhood development areas. And so there are, with those designations, with a village center designation, there are certain property tax credit benefits that are available for properties within those designated village centers for doing rehabilitation work on properties. Um, and we have a number of village centers. And Patty, as you know, Londonderry has two village centers in South and North Londonderry. I will say just briefly, with the Act 181 legislation in 2024, the state designation program had is going through a process of being reformed. So all of the existing village center designations and downtown designated downtowns will remain and retain that designation, but that program is being revamped under Act 181. And we are going to have a workshop next Thursday evening that's going to cover Act 181 and those designation changes. So, and that will be recorded and posted on our website too. So I'm happy to follow up, Patty, on the designation program, but it's similar to the energy siting. It's a longer follow-up conversation, but happy to chat with you later about that too. So I think I'll continue on. Just I know we have a lot to cover, so I'll try to speed things up a little bit here. So that covers the kind of the town planning process. And the next section, I'm going to be talking about moving into plan implementation. Just to note, this section is briefer than the first section about town planning, and then sections 3 and 4 about roles and responsibilities and meetings and hearings. Those sections are shorter too, so I do recognize that we're trying to wrap this up at 1:30, so we'll try to keep it to that or just a few minutes over. So once you have a town plan adopted and you're moving into implementing the town plan, there are two primary ways that the town plan gets implemented. There's regulatory implementation, and again, that's through zoning and subdivision bylaws, flood hazard bylaws, and local ordinances. And then there's also non-regulatory implementation, so that could be making improvements to public facilities based on a identified need in your town plan. It can be informing and engaging with residents. So it could be setting up a advisory committee to look at a specific issue in more detail. Often, because the town plan is a pretty high level planning document and can only get into so much detail on specific things. Often the town plan will recommend additional follow-up plans that are able to get into more detail so that, right, might be a specific plan for a village area or a lot of communities have completed housing needs assessments. So that's something that might come out of a town plan that you're not able to do within the town plan itself. So and so those are some examples of more non-regulatory implementation. Just to talk a little bit, just because I know we all have different levels of familiarity with zoning bylaws. So zoning is used to regulate the location, type, and density of development through the creation of zoning districts across a community. It's important to note that there's no one right way to write zoning bylaws. You are required to follow state statute requirements for what needs to be included in your zoning bylaws and what's prohibited within your zoning bylaws, but it depends on the community and its goals. Some towns have zoning bylaws that are 100 pages long. Some towns have zoning bylaws that are only 50 pages long. It depends on like the level of detail that you want to address through your zoning. So I think it's important for towns to keep in mind that still within the parameters of state statute, there's a lot of ability for towns to create land use regulations that are reflective of their own community. But the general organization of zoning bylaws, again, you have your zoning districts and a zoning map, so showing where those zoning districts are across the community, general regulations that will apply to all uses. So those are things like minimum lot size requirements, structure setbacks, things like that, building height. And then you may have standards for specific types of uses in your community, things that might have a greater impact. You might want to develop more detailed standards for those types of uses. You need to include a development review process. How do things get approved in the community? What are the administrative requirements? And then all zoning bylaws have a definition section too, just so that the terms you're using are clearly defined and people understand what's expected of them based on those definitions. So in terms of the types of review, when it comes to zoning, there are different there's different processes for review depending on how things are classified within the zoning. So a permitted use is just allowed within a district by right. It may just require a zoning permit from the zoning administrator. A conditional use is generally a use that is appropriate in the district, but because of the nature of the use, additional criteria need to be met. So often for a conditional use, there's some external impact that the use might have. So it might have a greater impact on adjacent communities in terms of compatibility, traffic, noise, lighting, things like that. So it's a type of use where the town wants to apply some additional review and regulation on to make sure that it is still appropriate within that zoning district. The site plan review process can be used to establish site design standards, addressing things like parking, landscaping, lighting, and screening. And so a site plan review can be required for all uses except for single family and two-family dwellings. Variance, that's a deviation from the underlying zoning standards. So it's not uncommon for a property owner to want to do something that doesn't meet the zoning bylaws. And so the variance process allows them to request for that exception. There are very strict standards in statute for when towns can grant a variance. So in response to that, several years ago, statute was updated to allow towns to grant waivers. So these are more flexible local standards. So again, if someone's looking for an exception from the zoning bylaws, it can be easier for them to apply for a waiver if a town allows for that process. But the waivers are from dimensional standards. So that could be a structure that is too close to a property line, for example. So that would be a waiver from a dimensional standard. So not all towns have a waiver process, but it can be good to have that in place to be able to grant that flexibility to property owners. And then planned unit developments, zoning bylaws are required to include provisions for planned unit developments. These allow for more flexible design for larger scale projects, including commercial and residential developments. So residential developments, it's often allowing residential dwellings to be more concentrated on a lot. So clustering homes and allowing a developer to set aside more land for shared use by property owners within the development or for conservation purposes. Planned unit developments are often used too for larger commercial projects that are that cover multiple properties. It might have shared facilities like a shared parking lot or shared entrance to the site. And then for subdivisions, the subdivision regulations control how properties are divided into smaller lots. And having those regulations controls the pattern of future development in the community. So subdivision regulations can be included in your zoning bylaws, or you can have standalone subdivision bylaws. Subdivision bylaws allow the town to control more in terms of how properties are laid out, what public facilities need to be provided with a major subdivision application, um, things like that. So I think it's helpful to have subdivision bylaws in addition to zoning bylaws to help control that pattern of development and how it occurs. Towns can also have unified development regulations where their zoning and subdivision bylaws are combined into a single regulatory document, which makes it a little easier to navigate those different requirements. So there are limits of local land use regulations. So land use regulations tell people what they can and can't do with their property, but they can't deprive a landowner's right of all reasonable use of their property. So there still needs to be the provision for some use of the property. Again, towns can only regulate what's enabled in state statute. And I would recommend reviewing Chapter 117. So this is the chapter I referenced at the beginning of the presentation. This includes required provisions and prohibited effects and limitations. So this is required provisions in your zoning bylaws and things that are prohibited. So I won't list them all out here, but there are certain requirements in statute when it comes to housing, home occupations, childcare, agricultural uses. And those are um, very detailed in statute. So you just want to make sure your zoning bylaws conform with those statutory requirements. And then as I mentioned, with the annual legislative process, there's often changes to statute requirements. So making sure your land use regulations are kept up to date with those changes. So I think we're all familiar with the Home Act in 2023 that included certain requirements for provisions of housing in communities. And then Act 181 last year included some additional housing requirements. So making sure the zoning is updated to address those changes in statute. And then this is a question we get sometimes, which is what the difference is between a bylaw and an ordinance. Bylaws those are the regulatory tools that are governing land use. Chapter 117 lays out the process for the adoption and enforcement. So that includes zoning, subdivision, and other types of regulations like flood hazard bylaws. In ordinance, the adoption process is in Chapter 59 of 24 VSA. And these are more rules and laws that are adopted by the select board. So they can be for any purpose authorized by statute. So it can be for animal control, noise, town highways, driveways, in response to the increase in the number of short-term rental units. Some towns have adopted an ordinance to address short-term rentals. They can also be addressed through zoning bylaws, but an ordinance is another way to address short-term rentals. And the adoption of an ordinance, that process is somewhat more straightforward than the adoption of a bylaw. So it can be an easier way for a town to put in place regulations than going through the bylaw process. And this is my last slide on just the implementation section, and then I'll pause and can respond to questions. So there are a lot of examples of non-regulatory implementation of a town plan, but I think it's helpful to just think about how these non-regulatory tools help complement your regulatory implementation through zoning bylaws. Again, Chapter 117 has specific tools that towns can use to implement their plans. So it authorizes a capital budget and program, so that would be a town inventorying all of its existing capital assets, so town facilities, its infrastructure, any utilities it owns, and then figuring out the life cycle of those assets, when things need to get replaced and maintained, and figuring out a process for how that's going to be funded and paid for. And other non-regulatory tools are purchasing and accepting development rights. So that could be helping conserve land within a community. Again, supporting plans, so like follow-up specific plans that are recommended in the town plan. Advisory commissions and committees can be formed to help advise the select board on specific issues. Many towns have a conservation commission. The planning commission can also be assigned follow-up efforts from the select board to work on after the town plan is implemented. Some towns have formed housing committees or economic development committees to look at those specific issues in more detail. And then just other projects and studies that your plan might recommend. So there's lots of ways to implement your plan other than just through regulation. So I'll pause there just before going on to the final two sections.
Yeah, we have a few questions in the chat. Um, One is more of like a planning process related question, and the others have more to do with implementation. I don't know if you'd like to uh, do the process question first and then the
Sure. Yeah, I
implementation
can.
questions.
Yeah,
Yeah.
respond to that first.
Yep. So this is from Kathy Edgerly. When you are doing planning workshops, especially those being facilitated by an outside consultant, we have had two different pieces of advice as to whether these would have to be warned in advance. What has been your experience with this?
Oh, it's a good question. I mean, my take on it is, if you're holding a public meeting as part of the town plan update process, um, my take on it is you do not need to warn that as an official meeting of the Planning Commission, even though you might have a quorum of Planning Commission members there, because it's not a meeting. It's not a meeting of the Planning Commission. They're not gathering to take any formal action. That's that's my take on it. Sometimes for a town plan meeting, um, sometimes the Planning Commission will hold a more formal meeting as part of one of their regular meetings and ask for feedback. So if it's if they're looking for public input kind of as part of their regular meeting, then certainly warn it as a regular Planning Commission meeting. But again, This is where I can't provide legal advice, but my take is if it's just a public meeting, you don't need to warn that as a official meeting. Um, and then let's see. And then I see, looks question from Sarah. So yes, there are statutory requirements. So statute does specify, or there are provisions in statute for how a municipality needs to address the waiver process in their bylaws. But the town does have a fair amount of right latitude about how they set those up, but there are some like broad parameters in the statute. Um, and that's something too. I'm happy to follow up with you, Sarah, on that. I can't recall the specific requirements in statute, but there are at least some parameters in there. Um, and then I see a question from Kathy about minimum unit number for a planned unit development. That's a good question. I I don't know um, if that's required, if there's anything about that in statute or not. I mean, I think it's pretty common for towns to set a minimum in their zoning bylaws. Um, but that's something I could follow up with you about, Kathy. Um, let's see. And Sarah, question about, yeah, how do you update the zoning bylaw based on statute when statute can change annually? Don't changes to the bylaw take a lengthy process? Yes, I sympathize with that. So it's, I would say it's not every year that there are changes to statute that would require you to update your zoning bylaws. The Home Act was a pretty significant change to statute in terms of the requirements for housing, and did require more extensive updates for a lot of towns. Um, I think my advice is recognizing that it takes time to update zoning, and many of our towns I, don't have administrative staff to support a planning commission to do that work. We're here at WRC, we can provide technical assistance on what changes need to be made, but a lot of that work falls on volunteer planning commission members. Um, I think keep in mind too, even if your zoning, for example, if your zoning hasn't been updated based on the changes from the 2023 Home Act, those changes to state law still apply. So even if it takes you a couple years to update your zoning, just make sure that if an application comes in, that that I'm trying to think of if an application comes in that complies with the new state requirements and statute, but your zoning hasn't been updated, you still have to process that under the state statute requirements and approve something, even if your zoning hasn't been updated to meet the new statute requirements. So I think just trying to update your zoning as soon as you can after there are changes in statute, but recognizing that it takes time. So just keep in mind the changes in statute and make sure you're always referring back to statute, and consult with a town attorney if needed, if there's any confusion over that. I know with the changes in the Home Act in 2023, that's been an issue, just because, like I said, it was pretty extensive changes to statute, so it's taken towns some time to make those updates. So, okay, if there aren't any more questions, I'll continue on. Let's see. So the next section, I'm going to go over just the basic roles and responsibilities when it comes to land use planning and regulation. Okay, so this is just looking at local roles and responsibilities. So these are really they're delineated by both by what's required in statute and then by function. So generally, you have legislative, quasi-judicial, and administrative roles in your town. And legislative, um, these are the entities that are responsible for writing plans and bylaws and adopting them. Quasi-judicial, these are entities that are responsible for reviewing proposals and permitting a proposal. So they're interpreting what's being written and adopted by the legislative entity. And then administrative, that's the entity that's responsible for issuing a permit or denying a permit, again, based on the rules and regulations by the legislative entity. Oop. So to kind of break this down, just so it's a little easier to understand. So in your community, the legislative body is the select board. Um, so in addition, the select board has assigned, or some legislative responsibilities are assigned to the planning commission in terms of preparing the town plan and preparing zoning bylaws. But it's the legislative body that's approving the town plan and approving the zoning bylaws. So the planning commission is just responsible for writing those documents. The quasi judicial function, so that can either be, traditionally it was the zoning board of adjustment and planning commission both filling that role. But now communities also can have a development review board that takes on that quasi-judicial responsibility. And I'll go over that in more detail on the next slide. And then the administrative role, that's the zoning administrator that's appointed by the select board. So the legislative function, again, the planning commission members, they're appointed by the select board. They're preparing the municipal plan, preparing zoning bylaws. They can prepare a capital budget and program if that's assigned to them by the select board. And then there might be other studies that they prepare, or they might hire a consultant to prepare as directed by the select board. But again, the planning commission, they're appointed by the select board, so it's very important for that communication to go back and forth between the planning commission and the select board, so that select board and planning commission are on the same page in terms of the work that's being done. The select board, they receive the town plan from the planning commission. They can make changes to the plan after the planning commission is done with it. They have their own public hearing process. They also can edit zoning bylaws and development regulations that are proposed by the planning commission. And they can adopt them, or they can send zoning bylaws to voters for approval. One thing to note, one change under the Home Act from 2023 was a change regarding the zoning bylaw adoption process. So previously, towns with a population of less than 2,500, which are defined as rural towns in statute, previously those smaller towns could vote at town meeting to require that zoning bylaws be approved by voters at town meeting. With the changes in statute, that provision was removed, so that the legislative body, the select board, votes to adopt the zoning bylaws. The select board they still have the option of putting bylaws to a vote by the residents, but that's at the decision of the select board now, rather than by voters making that decision at town meeting. So that's just if you're a town where previously you had zoning bylaw amendments voted on at town meeting, that's just something to keep in mind if you're considering upcoming zoning bylaw amendments. And then once a select board adopts a zoning bylaw, voters can still petition for a popular vote of the bylaws after they're adopted. So this slide just helps explain that quasi-judicial function in more detail. So again, these are the two options the town has for that quasi-judicial function. So if they have a development review board, the development review board reviews all of these applications for site plan review, subdivision, conditional use, variances and waivers, or if there's an appeal of a decision made by the zoning administrator. The other option is, and this is what was done previously before development review boards were an option, is the planning commission is responsible for approving site plans and subdivisions, and then the zoning board is responsible for conditional uses, variance and waivers, and appeals of the ZA decision. So either option is fine, but those are kind of the two ways to cover the quasi-judicial responsibilities. And then administrative function. So the zoning administrator is responsible for reviewing and issuing zoning permits. They also can help consult with an applicant and just help them make sure they're providing the necessary information and understand the zoning bylaw requirements. They conduct enforcement if needed. So violations of the zoning bylaws, making sure that a construction project is completed in accordance with an approved permit. And then depending on the town, they might provide staff support for a DRB planning commission or ZBA for applications that also require approval by one of those bodies, but it just depends on the town and the role of the zoning administrator. When it comes to regulatory decisions, so these are for the DRB, ZBA, or Planning Commission. The issues have to be, or the decisions have to be issued in writing. And this is taken from statute. Those decisions have to include a statement of factual basis on which the appropriate municipal panel has made its conclusions, and a statement of the conclusions. So it's very important to base your review entirely based on the regulations that you have in your zoning bylaws. Your meeting minutes might be sufficient. Some towns take very detailed meeting minutes. So if your minutes contain all the necessary information, that might be sufficient. But it might be preferable to issue that decision in writing just to make sure you're covering all your bases. This is from statute 2, the quasi-judicial panel shall adjourn the public hearing and then issue a decision within 45 days after the adjournment of the hearing. Failure of the panel to issue a decision within that period shall be deemed approval and shall be effective on the 46th day. So just really important to keep that requirement in mind after you close the public hearing on an application, that a decision needs to be made within that 45-day period. But you don't need to rush the decision either. So the decision doesn't need to be made the same day as the hearing. So if there's an appeal, so if it's a appeal of a decision of the administrative officer, the zoning administrator, that goes first, that has to go to the Development Review Board or the ZBA. If it's a decision that's made by a DRB, ZBA, or Planning Commission, that gets appealed to the Environmental Division, the State Environmental Division. And then statute defines or statute spells out who gets to appeal. So it can be the applicant, it can be the town or an adjoining municipality, property owners in the immediate neighborhood of the proposed project. It can be any 20 persons within the community. That can be a combination of voters, residents, or property owners by assigned petition. Um, this one is one that has changed in recent years. The statute's been changed to add residents and also increase the number of persons from 10 to 20 persons that need to sign the petition. Any department or administrative subdivision of the state owning property or any interest in property within a town can appeal, and then the Agency of Commerce and Community Development can also appeal. It's important to note only interested persons that have participated in the process may appeal. So someone needs to have attended a public hearing, provided their name, let the town know that they are an interested person in order to have standing to make that appeal. Another change that was in the Home Act was an appeal by petition. So a petition by 20 persons within the community cannot include the character of the area if the project has a residential component that includes affordable housing. So that was added in under the Home Act. So just that's something to keep in mind. And are there any questions about roles and responsibilities? I have a few more slides about meetings and hearings, which should take, I see we're at 125, so I probably have about 5 to 10 more minutes of slides. Just wanted to be respectful of people's time. I know we're covering a lot of information here, but I want to see if there's any questions before getting to the last few slides. And you can always send me an email too. So I'll keep going ahead. Okay. So I just want to go over the difference between a meeting and a public hearing. So this is just showing what happens at each and who is holding these different types of gatherings. So meetings, this is when an entity is discussing business or they might be taking action. Meetings can be held by all public bodies within the town. A legislative hearing, this is where you're receiving public comments on a proposed town plan or a bylaw update. Legislative hearings are held by the Planning Commission or Select Board only. The quasi-judicial hearings, this would be held by a DRB, ZBA, or Planning Commission. You're hearing from parties that are seeking board approval. And so this is any board that is responsible for reviewing that proposed development. There are different public notice requirements. So always refer to statute to make sure you're following the required public notice requirements. But just in summary, for For a regular meeting, you need to provide at least 48 hours notice of that meeting by posting the agenda in or near the town office and two other designated places. For legislative hearings, so this is for preparation and adoption of town plans and bylaws. You need to provide 15 days notice for those hearings, except the planning commission has to provide 30 days notice for its town plan public hearing. It needs to be published in the newspaper of record and posted in 3 or more public places. And then there are also certified mailing requirements for adjacent towns. For quasi, well, one thing too to mention with the legislative hearings, you can also do an electronic distribution for the town plan or zoning bylaw public hearings. Sending that notice out by email and just requesting confirmation of receipt. So if you're distributing information electronically, I recommend saving a copy of emails that you send out just in your records in case there's any question that you can point back to when those emails were sent out, complying with the hearing notice requirements. And then for quasi judicial hearings, so it's either 7 or 15 days, depending on the type of application. And again, that's spelled out in statute. So similar notice requirements, you need to publish in a newspaper, posting in 3 or more public places, mailed to the applicant and abutting property owners. And then you need to post within view of the nearest public right-of-way of where the project is proposed. Vermont open meeting law. I'm not going to go into detail about the open meeting law requirements. I would recommend if you're looking for more information about the open meeting law, the Vermont League of Cities and Towns has a lot of helpful information about open meeting law requirements. And so just in the interest of time, I would just direct you to VLCT for more information. But it's again important to meet or to make sure you're following all those notice requirements for your meetings, making the agenda available, letting the public participate. Draft minutes need to be available within 5 calendar days of the meeting. And then if someone brings a complaint that the town has violated open meeting law, there's a process for the town to address that. So just making sure you're responding and addressing complaints that are received. Just the process for holding a quasi-judicial hearing. So it's important for the chair to follow a process of opening the hearing, making clear what the expectations are. So the applicant has an opportunity to present the proposal first. Board members ask questions of the applicant in relation to your land use regulations. So it's always important in reviewing a proposal and discussing it with an applicant to tie it back to provisions within your zoning bylaws. After that, the chair can open it up to comments from members of the public. Then the public hearing is closed after everyone has had an opportunity to speak. And then the board decides on the application and issues a written decision. So again, this is just the process for the public hearing. It's important to just provide an explanation of the process at the beginning of the meeting, remind participants about the importance of order. If the town has rules of procedure and ethics policies, making those available. reviewing that definition of interested persons, and if anyone is looking to be involved in the process, making sure that they identify themselves so that they can be counted as an interested person. And then just requesting disclosure of any conflicts of interest or ex parte communication, which I'll get into in the next slides here. Um, and so the chair of the board does have a responsibility in kind of managing the process, managing the meeting, making sure that everyone stays on task and is referring to the zoning bylaws in their review and discussion process, um, and then bringing the board to a resolution after there has been an opportunity for discussion. Board members at a quasi-judicial hearing. Again, it's important to listen to the testimony and evidence, review materials ahead of the meeting, ask questions, refer back to your local regulations, avoid potential conflicts of interests, base your decisions on the evidence presented. So, you need to make your decision based on the materials provided in the application and what you've heard from members of the public. It's important not to prejudge a matter or express your opinions about a pending case before a decision has been made. After the public hearing has been closed, the quasi-judicial board can have a deliberative session. These are exempt from the open meeting law requirements. Um, so it's a chance for the board to discuss the application and develop their decision in writing. You don't have to take minutes. You don't have to reveal how the board members voted. Um, it can be a private meeting, it can be open to the public. And again, the board has 45 days to issue a decision from the close of the hearing, or the approval is deemed issued. And I just have two more slides here, and then we'll wrap it up. Just just to briefly go over potential conflicts of interest. So it could be a member has a financial interest in a project, either direct or indirect. They could have some direct personal interest. They might have a known bias or prejudice against a project or an individual bringing an application forward. Um, or there might have been ex parte communication. So ex parte communication, that's when members of a municipal panel are having discussions outside of a noticed meeting, either between one another or with an applicant or with members of the community that are interested in the outcome of the project. So that's where you're discussing the project outside of the formal public meeting that's been noticed. So that's also a reason for recusing yourself from a decision on an application. And I just think it's important to note it can take a lot of time to build public trust, but it can just be one misstep by a board to destroy it. So if you for managing conflicts of interest, I think it's always best to err on the side of recusing yourself if there's a potential conflict of interest, because you really don't want to erode the public trust in the public body. There are templates for rules of procedures and ethics that towns can adopt, so it's important to follow those. It's it's very hard to avoid ex parte communication. Just living in small towns, we run into people we know, and they might have an interest in a project and want to talk to you about it. But you just have to just be very clear that you can't talk about a project outside of a meeting. Um, so I know it's difficult to avoid that. And then this is a reason why it's good to have alternate members for your different boards and commissions. So if someone does have a conflict of interest, you have someone that can step in and sit on that application, because they do come up, conflicts of interest. Okay, so just in summary, for protecting the due process, make sure you're providing proper public notice, give people an opportunity to be heard at public hearings, conduct an orderly proceeding, ensure proper management of evidence in the application, and then make sure you're managing any conflicts of interest um, in the decision-making process. So that I appreciate you all sticking with the presentation. Let's see, I'll turn on my video here. Those are the slides I have. The last two slides are just some helpful resources that are available online. So this is the state planning manual for the municipal plan. This just walks through recommendations on how to approach the town planning process. There's the essentials of local land use planning and regulation, plan and bylaw adoption tools. So that kind of provides you step by step the notice requirements and adoption process for town plans and bylaws, and then the rules of procedure and ethics manual for planning commissions, DRBs, and ZBAs. And then these are tools and resources that are available online. So the first one is and I'll be posting this presentation and the recording on our website so that you have access to these links. But the first one is the link to state statute, and then our website, Wyndham Regional, Vermont League of Cities and Towns, and then Department of Housing and Community Development, and then my contact information as well if you don't have that. So that's all I have. I'll look at the chat box to see if there are any more questions. Let's see. Yes, thank you, Sarah, just about the comment about meetings can be continued to allow for additional document collection or testimony. So that's right, like a public hearing, you don't need to conclude a public hearing at that first meeting. Like if it needs to be continued, that's okay. It's that 45-day clock starts after you close the public hearing. So if the town doesn't have the information it needs to make a decision, like just I think it's important to be clear about, we need this additional information to be able to make a decision and not close the public hearing until you get that information. And then Sarah, I see your question. My understanding was that votes can't be taken in deliberative session. The application is discussed and then the vote is taken after coming out of deliberative session. Then I will follow up with you on that, Sarah. Because I'm not sure on that one. But that's a good question. Are there any other questions? Uh, let's see. Yes, Sarah. So I will post this. I will post the PowerPoint presentation on our website along with the recording. So if you have other members of planning commissions, ZBAs, or DRBs in your town that might be interested in looking at the slides or hearing the presentation, you can direct them to our website. It'll probably take a day or two for everything to get up there. So, but in the next couple days, that'll be available. But thank you all for joining us this afternoon. And again, we're here as a resource. So if you have follow-up questions or if it would be beneficial to come meet with a board or commission in your town, we're happy to do that.
Thank you, Matt.
Thanks, Stephen.